Unit 12, Risk and Environmental Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Identify 4 methods of risk management and the implications of each. Describe insurance policies that the owner, the manager, and the tenant should carry and discuss the need for and coverage of each. List environmental laws and give a simple explanation of each. Name environmental hazards and describe ways that the property manager can minimize their effects. Explain the importance of employee information and training for dealing with hazardous substances. Overview. In addition to all the other tasks and duties discussed in preceding units, the manager handles office records as well as the principal's funds and important documents. Insurance against loss of these documents or the property itself during the routine performance of the manager's duties is valuable protection for both parties and should be purchased by the manager as a good business investment. The property owner may consult the manager, but the final decision about any property insurance should be made by the owner after consulting with his own insurance agent. Although the manager has no insurable interest in the property itself, the manager should be named as a co-insured on all liability insurance policies that the owner holds on the premises. The usual form of a manager's general liability insurance policy does not cover accidents arising because of the management of properties. Environmental concerns require an increasing amount of management time and attention and may affect the availability of insurance as well. This is especially true regarding moisture claims and flood insurance. And after paying out huge settlements for mold-related claims, many insurance companies are now excluding mold damage in the policies. With the proliferation of federal and state laws and increasing local regulation and enforcement, the area of environmental concerns has become a major responsibility of the property manager. Property managers are not expected to be experts in all the disciplines called on to operate a modern building properly. They are, however, expected to be knowledgeable in many diverse subjects, most of which are technical in nature, and environmental concerns fall into the technical category. The property manager may manage structures containing hazardous materials or be called on to arrange an environmental audit of a property under consideration for purchase. If hazardous wastes are produced by the manager's employer or tenants, the manager must see that they are properly disposed of. Even the normally non-hazardous waste from an office building must be controlled to avoid violating laws requiring segregation of types of wastes. In areas where recycling is becoming the norm, the property manager must provide recycling facilities and see that tenants sort their trash properly. Risk management and insurance. Learning objective. Identify 4 methods of risk management and the implications of each. One of the most critical areas of responsibility for a property manager, because of the potentially great dollar and personal losses, is the field of risk management and insurance. The property manager should have a working knowledge of casualty, liability, and special lines of insurance and an understanding of the whole insurance field, its theories, principles, and practices. Insurance has expanded from its beginning several centuries ago as a pooling of risks by merchants to its present-day sophistication, in which the professional insurance administrator is now called a risk manager. Premiums have skyrocketed, in large part because of lawsuits over the presence of mold. While the manager cannot prevent naturally occurring catastrophes, such as hurricanes or earthquakes, the manager can adopt risk prevention and risk reduction policies to minimize their financial effects. Risk management theories. The risk manager is concerned with both the financial and humanitarian consequences of unforeseen events and in taking steps to reduce those consequences. Risk management principles can be examined and implemented in the following ways. Identifying the risk and measuring its frequency and financial severity. Avoiding the risk or discontinuing the loss causing activity. Controlling the risk with safety programs, loss reduction plans, and emergency preparedness. Retaining the risk and internally funding loss consequences. Transferring the risk to insurers or to third parties. Monitoring the results and ongoing fit of the risk management strategies implemented. Having the tenant pay for or share extra costs for dealing with unusual risks or paying for specialized insurance. Identifying and measuring the risk. The risk manager begins the process with a survey of the physical structure, the operating equipment, and the tasks performed by personnel, particularly during maintenance. Contractors' insurance certificates should be reviewed. The property manager can access additional sources to assess various risks. For example, the internet, public records, and libraries can provide sources of weather, flood, and earthquake probabilities. Local fire departments may allow access to their information and offer suggestions on measuring fire hazards. Independent loss control firms conduct hazards audits, and some insurers offer professional loss control consultations. Property replacement costs and actual depreciated values should be obtained. Current contracts and leases and inactive contracts with remaining indemnities should be discussed with legal counsel. Avoiding the risk. The property manager should determine which risks can be avoided and which cannot. Windstorms, floods, and earthquakes cannot be avoided. They are known risks assumed by the owner. Icy sidewalks can be expected. Fires occur and are sources of property damage, loss of income, and injuries to employees, tenants, and the public. Property managers can, however, avoid some identified risks by not managing hazardous properties and by eliminating dangerous equipment and hazardous operations. Avoiding risk can be as simple as removing a diving board or replacing wood shingles with non-combustible materials, or as complex as arranging environmental assessments and removing pollutants. Also, the manager should hire only contractors who can provide evidence of insurance for workers' compensation and commercial or automobile liability. Controlling the risk. Some risk cannot be avoided. The property manager should consider ways to reduce the likelihood of the loss event occurring and to reduce its impact measured in terms of financial cost and human suffering. Emergency preparedness and adequate crisis response plans should be developed and regularly updated by the property manager. Installing fire sprinklers, signs, and physical barriers to warn people of hazards on the premises are examples of controlling physical hazards. Other examples include storing backup computer records off the premises and installing security services to prevent some losses and sound the alarm in others. Drivers can be asked to provide satisfactory motor vehicle records. Property maintenance equipment should be kept in safe working order, and the operators can be carefully trained and required to wear protective clothing and equipment. Mold issues are becoming a larger responsibility and liability issue in more recent times, so buildings of all types should be periodically tested with mold detection units in order to prevent any surprise issues. Outside contractors can be used for annual or semi-annual testing. The results should be kept on file. If a problem is identified, it should be remediated before a major expensive situation arises. Loss control can contribute directly to savings in insurance premiums. For example, workers' compensation, automobile and commercial liability, and multiple location property insurance agreements are individually loss experience rated by insurers. The well-managed risk is more desirable to underwriters, and premium credits can be substantial, up to 40% in some situations. Retaining the risk. After the principal risks have been avoided or reduced where possible, remaining risks require funding if the financial consequences of losses are to be absorbed. Internal funding either by cash or borrowing is nearly always the most economically efficient. With proper planning, reasonably expected loss costs such as dented fenders, broken windshields, minor vandalism, and plate glass breakage can be retained and paid for as ordinary business expenses. Increasing the insurance deductible is another way of retaining some of the risk. Usually the higher the deductible, the lower the premiums. Transferring the risk. Risks that cannot be avoided or internally funded must be transferred. Transfer techniques include shifting the hazardous activity to professionals with satisfactory insurance, contractually shifting the legal liability to others by written indemnities to the owner property manager, and transferring the risk partially or wholly to insurers. Shifting the hazardous activity to others may include hiring contractors to provide security, swimming pool chemicals, maintenance, and roof repair. Of course, the property manager still has supervisory duties. Contractually shifting legal liability to others is rarely a complete transfer of risk. Contractual indemnities must be funded by the indemnitor, therefore the owner must rely on the indemnitor's financial worth and insurance coverage. Transferring the risk to insurers, partially or wholly, is one technique for funding risks that cannot otherwise be retained, avoided, or transferred to others. Insurance is not a perfect transfer, however, because not all risks are insurable. For example, most policies exclude loss caused by nuclear contamination, asbestos contamination, enemy invasion, and war. Monitoring decisions. The property manager must continually monitor areas of risk to determine whether changes must be made to improve the effectiveness of the risk management plan. New operations or properties also must be evaluated for risk management. Property values must be updated at least annually and when improvements are underway. Key policy. Constant vigilance of insurance certificates on the part of owners, their subcontractors, and tenants is a vital part of risk management. The property manager should set up ongoing compliance suspense files. Property manager as a claim adjuster. Inevitably, every property manager will experience a loss covered by insurance. This may be as simple as a dented fender on a maintenance truck. However, it could involve extensive physical damage to buildings from fire, windstorm, or other disaster. In most cases, the property manager will be responsible for arranging preservation of the property and later negotiating with insurance company representatives, such as claims adjusters, to obtain fair settlement. The objective in any claim settlement is to compensate the owner for damages suffered in accordance with the terms and conditions of the insurance policies. For this reason, managers should have a thorough knowledge of coverage and limits and establish a good working relationship with their insurance agents. Adjustment of claims is an area that requires a great deal of expertise and experience. Adjusters representing insurance companies, particularly independent adjusting companies, may be intent on trying to minimize the amount of claims paid rather than making a fair settlement. If a property manager is not well versed in claims adjustment, an experienced attorney or well-established independent claims adjuster should be consulted. Property manager as a claim adjuster. Before any disaster, the property manager should be prepared by doing the following. Have easily available the names of the insurance company for each property and the policy numbers of the policies that cover the managed properties. Know the phone number of the agent that handles the policies. Have the number for the claim department of the insurance company. Have the phone number to call in the event of a catastrophe, as the number may be different than a regular claim number. It is helpful to have the insurance company inspector do an annual visual inspection in order to avoid surprises or conflicts. In the event of serious damage, the renter or property manager should call in the claim as soon as possible and take pictures of the damage. Then either or both should arrange for temporary repairs to prevent additional damage, keeping all receipts. The property owner should be notified as soon as possible. Insurance policies. Learning objectives. Describe insurance policies that the owner, the manager, and the tenant should carry and discuss the need for and coverage of each. Types of insurance. The basic purpose of insurance is to reduce loss caused by unforeseen misfortunes. Both property owner and manager are exposed to the consequences of loss or accidents and need the protection offered by various types of insurance. One term to remember is insurable interest. No one can buy insurance on something or even someone unless that person has a reason to be involved with the other entity or person. For example, the owner of the building can buy insurance to cover the building in case of a loss, but tenants will have to purchase their own insurance to cover what belongs to them. Owner's hazard insurance policies. A property owner wants to obtain the best insurance coverage against as many risks as possible at the most reasonable rate. Because different localities and conditions demand varied forms of coverage, the owner often relies on the experience and judgment of the property manager. Although the property manager should have a working knowledge of insurance and can make recommendations, ultimately the owner should make insurance decisions based on recommendations from the owner's own insurance broker. As a representative of the policy buyer, the insurance broker must determine the risks involved, shop the market for the best and most economical coverage, and then purchase the required policies on behalf of the owner. Homeowners who have moved out of their homes converting the home to a rental should be advised that their homeowner's policy must be changed. A home must be owner-occupied to qualify for the homeowner's policy. The landlord's policy offers less protection. Owner's hazard insurance policies. As discussed earlier, the property manager should consider several insurance covers. At a minimum, considerations should include the following: property insurance, including fire, lightning, windstorm, vandalism, and malicious mischief; flood insurance; loss of income, following damage to structures or their contents; additional costs for temporary premises that are required following a loss; rental value of leased premises that must be replaced by more expensive leases; workers' compensation and employers' liability for injury to workers; commercial automobile liability, including hired and non-owned automobiles to cover injury and damage by vehicles, commercial general liability, including liability for contractors, completed operations, product, and contractually assumed liabilities. The owners of a business renting a commercial building need to obtain their own business or commercial policy. They do not need any building or dwelling coverage if they are only renting the space. Commercial insurance. Multi-peril policies are designed especially for each type of property: apartments, office buildings, warehouses, row houses, and fireproof structures. Multi-peril policies usually contain related covers such as loss of income and premises liability. The insurance agreement. Policy exclusions. Limitations. Reductions. Policy conditions and warranties. Policy territory. The agreement section describes the named insureds, property and locations insured, premiums charged, the period of coverage, hazards and perils insured, and any endorsements altering or extending the contract. The second part of the policy lists exclusions, limitations, and reductions. Provisions in this section state that the policy is voided if the insured concealed material facts concerning the risk when applying for insurance. Suspending insurance. Many standard fire policies include a clause suspending or restricting insurance if the chance of fire is increased in any manner within the control of the owner. Some policies are suspended when buildings are unoccupied, have not been winterized, or sprinkler or alarm systems are inoperable. The insurer also must be notified of ownership and occupancy changes. New owners or interests are not insured until the insurer has agreed to assume the new interest, because underwriters rely on the good faith of the insureds and reserve the right to refuse the risk if ownership changes. Event of loss. Other clauses in the standard insurance policy will specify the procedure to be followed in the event of loss. The pro rata amount of liability, the rights and interests of the mortgage holder and co-insured, the insurance company's options for repair or replacement of the property, and the time within which a settlement will be made in case of loss are usually outlined in the standard forms. The annual premium for a basic insurance policy is computed by multiplying the amount of the insurance by a rate per $100 of insurance. It is imperative that a property be adequately insured, particularly as labor and construction costs rise. The owner should obtain a current estimate of the physically depreciated value of the building and replacement costs. Replacement versus actual depreciated value. Replacement cost insurance should be compared to actual depreciated value insurance. Note that neither of these terms is related to market value. Actual cash value insurance can be a problem on older buildings because partial losses will be reimbursed on a depreciated basis while repairs are at replacement costs. Replacement cost insurance guarantees that partial damage to old, depreciated property will be fully replaced by new construction. Consider a 10-year-old roof destroyed or damaged by windstorm. If the property is insured for its actual cash value, physically depreciated value, the policy reimbursement will be the value of a 10-year-old roof. A replacement cost policy will reimburse the cost of a new roof. This is an especially important consideration because the most likely loss is a partial loss. Cost of demolition after partial losses, should it become necessary, must be considered. For older buildings, insurance for additional expenses necessary to meet revised construction codes must be included if the building would need to be reconstructed. Key policy. The property manager should make sure that the owner carries adequate coverage and that coverage is increased annually to cover the increased value of the improvements. 80% co-insurance. The co-insurance provisions of an insurance policy are critical and often misunderstood. In the typical situation, the owner-manager has promised the insurer two things in return for a lower premium. Above-ground property will be insured to 80% of its full physical replacement cost or actual value cost. Insured will maintain insurance coverage on that property at 80% of the value insured basis. The responsibility for maintaining insurance to 80% of the replacement value or actual cash value rests with the owner-manager. Every property manager should track inflation and construction costs and at least annually review the property and liability limits of the insurance property by property. Key policy. The premium for $50,000 of insurance on a building without coinsurance is about equal to the premium for $80,000 of insurance on a $100,000 building using an 80% coinsurance clause. Insurers are reluctant to assume what they consider underinsured risks. If there is a loss of $40,000 on the $100,000 building insured for $80,000 with 80% coinsurance, the insurer will pay the entire loss of $40,000. If there is a loss of $100,000, the insurer will pay $80,000. But if the value of the building has increased through inflation to $200,000 and the insurance remains at $80,000, then a partial loss of $40,000 will be determined according to the following formula. Amount of insurance times 80% of what it should have been insured for. Partial loss equals insurer payment. Had the loss been a total loss, the insurer would have paid the policy limit of $80,000. The owner who has failed to keep the property insured to 80% of the value would suffer a loss of $120,000 if the $200,000 building were a total loss. For properties valued at $1 million or more, insurers may consider an agreed amount clause. Such a clause eliminates the possibility of a coinsurance penalty. In return, however, the insurer usually demands total insurance to value. All risks insuring agreements. Standard fire insurance policies cover loss caused by fire and lightning. Adding extended coverage includes causes of loss described as explosion, windstorm, tornado, hurricane, hail, riot, civil strife, falling aircraft, and smoke. Vandalism and malicious mischief perils can be added by endorsement. Some of the newer causes of loss forms combine all risks coverage on some subjects and specific perils on other subjects of insurance. All risks coverage, instead of specifying the insured causes of loss, promises to insure all causes of loss except those excluded. Machinery and equipment insurance. Boiler explosions have been the source of catastrophic loss of life. Standard fire insurance policies do not cover boiler explosion as a result of internal breakdown. Boiler and machinery insurance combines both risk of transfer to insurers and loss control by insurers' engineers. Boiler and machinery policies cover direct loss to the machinery, damage to property of others caused by boiler explosions, and bodily injury to persons injured in boiler explosions. The insurance can also be written to include loss of income and costs of expediting repairs. Machinery breakdown coverage is important for air conditioning and refrigeration equipment necessary to the use of the property or for preservation of food, furs, or chemicals. For example, retail stores often maintain freezers for food storage. Most multi-tenant buildings, residential or commercial, are obligated to provide heat. Any vehicles such as trucks, forklifts, or cars used in the operation of a property also must be insured, especially if numerous units are garaged together. Business interruption insurance and loss of occupancy. Business interruption insurance might include loss of rents, profits, and commissions after an insured loss. Extra expense insurance covers additional costs to rent temporary space after an insured loss. Loss of rental value compensates the owner for those properties occupied at favorable rents, often the case with long-term leases. These insurance policies may be a wise choice for properties with small profit margins and heavy debt loads. Flood insurance. No homeowners, renters, or building insurance policies cover water damage as a result of rising waters, nor can an endorsement be added. The policies must be purchased separately, and subsidized policies are available to any property owner located in a community participating in the National Flood Insurance Program, NFIP. Flooding can be caused by heavy rains, melting snow, inadequate drainage systems, or failed protective devices such as levees and dams, as well as by tropical storms and hurricanes. FDIC-insured lenders must require flood insurance on their collateral if the property is located in a special flood hazard area, SFHA. If the lender's loans are not adequately covered, the FDIC can impose fines and penalties and even cancel the lender's FDIC insurance. Even if flood insurance is not required by the lender, every property owner should still consider buying a policy. About 20 to 25% of all claims are from owners whose property is not located in a special flood hazard area. A preferred risk policy, PRP, can be written in non-special flood hazard areas if the property has never had a loss. A PRP has lower rates than the standard flood policies. However, it is not eligible for properties located in the special flood hazard area. Flood insurance does have upper limits of coverage. Private insurers can write policies for the excess coverage. Other types of insurance. Commercial general and auto liability insurance. Under the common law of negligence, the property owner has a duty to act in a manner, and to maintain the property in such a condition that others will not be injured on the premises. Failure to act in a responsible manner can result in fines, imprisonment, or a judgment decree for damages and penalties. Commercial general liability insurance usually covers legal responsibility and costs of defense for damage to real and personal property of others, including loss of use of the damaged property. Policies can be amended to include personal injury lawsuits alleging invasion of privacy, false arrest, libel, or slander by the insured or the insured's agents and representatives. The policy may be broadened to cover some contractually assumed liabilities as well as liability for the insured's products and completed operations. All of these covers may be necessary for the property owner. A completed operations risk may exist if a management company repairs the property of others. Owners and management companies also have products liability if they sell or rent property or equipment to others. Pollution liability insurance. Although excluded under commercial general and auto liability policies, pollution liability insurance is required by law for underground storage tanks, hazardous waste storage or disposal sites, and transportation of hazardous wastes. Even though specialty insurers are willing to assume liability for unintentional pollution hazards, the policies are expensive and limited scope. Further, nearly all of them are written on claims-made forms, meaning only those claims bought within the policy period are covered. Thus, the policies must be continued or extended for a time after the pollution risk has terminated or the polluted property has been sold or is no longer in use. Workers' compensation insurance. State statutes and federal laws on federal property require workers' compensation insurance. Workers' compensation policies are standard forms covering the worker benefits prescribed by law, excluding fines or penalties, and are available from private insurers, state funds, and assigned risk pools. States consider both injuries and diseases related to the workplace as compensable. A person suffering a hearing loss, for example, may be compensated in many states. Managers need to be sure that companies with a number of lower pay employees are paying workers' compensation insurance to the full amount for all employees. A problem can arise when the company pays some employees on the books and others off the books. Typically, this is an issue with smaller size companies and not larger or national companies. Employer liability insurance. The manager-owner of commercial properties may have duties and risks over and above those covered by statutory workers' compensation insurance. These risks arise under tort liability and may be insured against by the purchase of employer liability insurance, plus purchase of coverage B of the standard workers' compensation and employer liability insurance policy. When employee injuries or diseases are ruled not compensable by the workers' compensation courts, employees may sue under ordinary negligence laws. Occasionally, employee family members sue the employer for wrongful death or loss of consortium. This type of insurance may also defend claims brought by employee family members who allege pollution brought home by employees from the workplace. Employers' liability insurance covers claims brought for unsafe workplace injuries. Third party over suits. Employees injured by a product often sue the manufacturer for negligence. If the employee prevails in such a lawsuit, the manufacturer may try to pass this negligence award back to the employer. The basis for such suits against the employer, called third party over suits, is that the product that injured the employee was modified, misused, or poorly maintained by the employer, or that the employer did not properly train the injured employee. Another source of lawsuits under this cover are employer-producer situations where the employee is injured while using a machine or product manufactured or modified by the employer. The growing number of third-party over suits against employers mandates the purchase of employer liability insurance. Special considerations. A growing trend in law expands the responsibility of employers of workers and independent contractors. Often, workers' compensation courts will rule that subcontractors are in fact employees for the purpose of compensation claims. Also, under no-fault laws, workers and subcontractors are nearly always considered employees, regardless of the contract for hire. Managers must not neglect to obtain contractors' certificates of insurance for workers' compensation. The property owner's insurer will assess full workers' compensation premiums of uninsured contractors, insurance for the tenant. As a standard practice, the property manager should notify, in writing, all tenants, residential, commercial, and industrial, that they must obtain renter's insurance to protect their personal belongings. It may help to explain insurable interest, stating that the landlord cannot buy coverage if they do not own the property. Business tenants renting a commercial building can obtain their own business or commercial policy. They can obtain business insurance through their own insurance agents. They would not require building or dwelling coverage as they are only renting. Families or individuals who are renting an apartment, house, or condominium need an H04 or renter's policy. These policies are offered through the personal lines marketplace and insure the tenant's personal property. They can also obtain flood insurance to cover their personal belongings. Insurance for the manager. The manager, as both a custodian and a contracting business person, may hire employees or contractors handle client funds, documents, and records and maintain an office and files. Common sense dictates that the manager should insure office contents, equipment, and supplies, as well as computers and software. The manager should also purchase employee dishonesty insurance to cover money, merchandise, and any other property for which the manager may be held accountable. Loss of valuable records, theft, holdup, and messenger robbery insurance should be carefully considered. The manager should also carry errors and omissions insurance with limits of at least 10% of the total annual collections to protect against possible accounting mistakes or other oversights, including failure to act. Allocating cost of risk management between manager and owner. Property managers must be aware of the risks they assume when they agree to manage a property. Most property owners feel that they are hiring an expert when they hire a property manager and are paying for that manager's expertise. Thus, owners believe that the manager should protect the owner from any liability that may arise from management activities. However, few property managers can afford to be exposed to the kind of liability that could result from their management activities. Limit management responsibilities. There are several ways for a property manager to control or limit liability. To begin with, the manager can try to control liability by limiting management responsibilities. For example, when using outside companies such as janitorial services or security, the contract should be between the third party and the owner whenever possible. The property owner's name should appear on the contract with the manager listed only as the agent. Bid bonds. Service and construction contractors should be required to post bid bonds from a reputable surety insurer before work begins. Bid bonds are ordinarily furnished by the surety company without premium charge. The manager thus knows that the contractor awarded the work will be able to furnish a performance bond guaranteeing completion of the work and payment of suppliers and workers. Named additional insured. In addition to carrying his own insurance, the property manager should ask to be named additional insured by the property owner's liability and property insurers. Ordinarily, there is no extra premium charged to the owner. The manager should also ask that the owner's property, liability, and workers' compensation insurers waive their rights of subrogation against the property manager. Property managers should require certificates of insurance from the owner's insurers evidencing these endorsements and each insurer's promise to notify the manager if the policies are canceled, non-renewed, or materially changed. Indemnity clause. Another way to manage risk is the indemnity clause. An indemnity clause in the management agreement can require the property owner to indemnify the manager for any damages not caused by the manager's own negligence or willful misconduct. This would help protect the manager even in cases where damages occur where there is no negligence on anyone's part. Any indemnity required from the manager to the owner should be worded so that the owner is protected only against foreseeable damages caused by the manager's negligence or willful misconduct that occurred during the course of management duties. The property manager should include in the management contract a clause that the manager is responsible only for her best effort in coordinating outside services and is not responsible for the work performed by contractors beyond ordinary supervision or products supplied by vendors. Managers should also consider putting a dollar cap on the amount for which they would be responsible. For example, the manager may include a clause that states she will be responsible for damages caused by negligence or misconduct up to the dollar amount of all compensation earned to date. Environmental laws. Learning objective. List environmental laws and give a simple explanation of each. Environmental legislation. Myriad federal, state, and local environmental laws affect property managers in connection with acquiring, owning, managing, or disposing of real estate. Managers must work to ensure the health and safety of their own employees and their tenants, and for the community at large. Keeping up with current law, regulation, and legislative trends will be critical to the success of property managers for the foreseeable future. Knowledge of specific hazardous substances and hazardous waste is essential. The terms hazardous substances and hazardous waste are often used interchangeably, but they are not synonymous. A hazardous waste is generally a byproduct of a manufactured item which itself may not be subject to environmental law or regulation. A hazardous substance, however, is broader in scope and may include everyday items such as household cleaning products and paint. Not all property managers must be aware of all of the following laws discussed. Some will be more relevant to residential, others to commercial and industrial. Environmental legislation. If the owner of real estate uses it in a manner that unreasonably interferes with another person's enjoyment of nearby property, the law provides a remedy in the form of suits to abate nuisances. Nuisance actions, however, were not designed to deal with serious pollution problems, which require a strong overall solution. To meet this need, governments at all levels had passed federal legislation laws to abate air and water pollution by the late 1950s and early 1960s. Increased concern in the 1970s over the quality and future of the environment produced new laws and further demands for action from the public. A brief review of principal federal laws concerning the environment follows, but property managers are reminded that additional state and local laws, many of which go beyond federal requirements and are more stringent, should be examined. One of these is the Lead-Based Paint Hazard Reduction Act. The National Environmental Policy Act. The National Environmental Policy Act, NEPA, which went into effect in 1970, requires the preparation of an Environmental Impact Statement, EIS, in advance for every major federal action that would significantly affect the quality of the environment. An Environmental Impact Statement must set forth the environmental impact of the proposed action. Evaluate impacts that cannot be avoided. Evaluate alternatives to the proposed action. Distinguish between short-term and long-term impacts, and list any irreversible consequences to natural resources. The National Environmental Policy Act. The National Environmental Policy Act, NEPA, which went into effect in 1970, requires the preparation of an Environmental Impact Statement, EIS, in advance for every major federal action that would significantly affect the quality of the environment. An Environmental Impact Statement must set forth the environmental impact of the proposed action. Evaluate impacts that cannot be avoided. Evaluate alternatives to the proposed action. Distinguish between short-term and long-term impacts and list any irreversible consequences to natural resources. The National Environmental Policy Act. Government agencies at all levels and interested citizens are allowed to comment on the potential environmental impact of the action, and citizens may go to court to force compliance with environmental law. It is important to note that states and some local governments have similar environmental impact laws that require EISs for major public and private developments. The Environmental Protection Agency, EPA, was established in 1970 to centralize the federal government's environmental responsibilities. Congress has charged the EPA with enforcing the legislation covering air and water pollution, toxic pesticides, waste disposal, and so on. Initial efforts were aimed at obvious pollution problems, those that could be seen, smelled, or tasted, but as controls regulating those areas were implemented, the focus changed to problems that were less visible but even more dangerous, such as those posed by toxic substances. Clean Air Act. The Clean Air Act of 1970 established a comprehensive approach for combating air pollution by requiring the EPA to set national air quality standards for major pollutants that have an adverse impact on human health. Ambient air quality standards are prescribed in two levels: primary standards designed to protect human beings from harm, and secondary standards designed to protect the environment itself. The Clean Air Act also directs the EPA to regulate the emission of toxic air pollutants, and under this authority, EPA has set standards for a number of pollutants. New stationary sources, such as factories and power plants, must install the most effective technology available for reducing air pollution. Property managers of industrial property will have more concern in this area than those who manage commercial property. They should review local ordinances as well. In 1991, the Clean Air Act was amended to include laws to protect the stratospheric ozone layer. Since then, refrigerants must be properly recovered from air conditioning and refrigeration equipment. The environmental and financial penalties can be assessed of up to $25,000 per day per violation of the Act. Clean Water Act. The 1972 Clean Water Act amendments to the original 1948 law were as all-encompassing in the water pollution field as the Clean Air Act was in air pollution. The amendments contained two basic goals: to achieve water clean enough for swimming and recreational uses and for the protection of fish and wildlife, to have no discharges of pollutants into the nation's waters, Although neither goal was reached by 1994, an EPA report did cite dramatic improvements in the conditions of water sources in most parts of the country. There may also be state regulations under this act that control apartment project pools and chemical usage. Safe Drinking Water Act. In 1974, Congress passed the Safe Drinking Water Act to protect and improve the quality of drinking water. The EPA sets primary drinking water standards to provide minimum levels of quality for water to be used for human consumption. A program governing the injection of waste into wells was included. The primary responsibility for complying with federally established standards lies with the states. Amendments passed in 1995 set up new programs for technical assistance, operator training, restructuring, and capacity development to aid homeowners associations and other non-governmental entities to comply with the monitoring and treatment requirements of the Safe Drinking Water Act. States were also given authority to redirect federal funds to support administration of the drinking water program. Ocean pollution. A permit system regulating the dumping of all types of materials into ocean waters was set up by the Marine Protection, Research, and Sanctuaries Act of 1972. The EPA has the responsibility for designating disposal sites and establishing the rules governing ocean disposal, including incineration of hazardous material at sea. Resource Conservation and Recovery Act of 1976, RCRA. This is a management program intended to regulate the handling, storing, and disposal of hazardous substances. The EPA issues regulations that implement the Resource Conservation and Recovery Act, RCRA. In general, EPA regulations establish record keeping, reporting, inspection, and other technical requirements for hazardous substance businesses, violations of which can bring fines and imprisonment. Again, this is important for industrial managers and some commercial managers. Toxic Substances Control Act of 1976, TSCA. The Toxic Substances Control Act, TSCA, permits the EPA to determine which substances are likely to pose health hazards to human beings or to the environment and impose controls on the testing, manufacture, and distribution of such substances. A notorious example is polychlorinated biphenyl, PCB, an extremely toxic oil additive used in electrical transformers and other equipment during the 1960s and 1970s. Use of PCB has been banned and is now being eliminated in a phase-out program. Asbestos Hazard Emergency Response Act of 1986, AHERA. The Asbestos Hazard Emergency Response Act, AHERA, amended the TSCA and mandated that all elementary and secondary schools must be inspected within established time frames, and abatement action must be implemented where exposure to asbestos is likely. Because regulations that govern schools and other buildings may be expanded in the future in one form or another to private property, property managers should keep abreast of developments under AHERA. Comprehensive Environmental Response, Compensation, and Liability Act of 1980, Superfund. The Comprehensive Environmental Response, Compensation, and Liability Act of 1980, CERCLA, is the famous Superfund law, named because two trust funds were created to help finance cleanup projects and payment of property damage claims. CERCLA establishes a body of remedies available to state and federal governments, as well as private parties, for action against the release or threatened release of hazardous substances into the environment. Petroleum is not included as a hazardous waste for purposes of requiring CERCLA cleanup because federal regulations specifically exclude wastes associated with the exploration, development, or production of crude oil or natural gas. Other laws govern that area. Superfund Amendments and Reauthorization Act of 1986, SARA. CERCLA was modified in 1986. The Superfund Amendments and Reauthorization Act, SARA, gave the federal government a lien on contaminated property subject to a federal government cleanup action, subordinate to all previously perfected security interests. SARA also limits liability for damages caused by normal application of pesticides registered under the Federal Insecticide, Fungicide, and Rodenticide Act, FIFRA, of 1972. Current and past owners may be liable for cleanup, so it is imperative that property managers monitor usage and storage of hazardous materials or anything containing oil or gasoline. State and local laws. Federal courts have discretion to exercise exclusive jurisdiction over state environmental law interrelated with federal law. The exact role played by local laws and governments in the management of hazardous matter is not yet well defined. A thorough environmental evaluation should be performed before the sale, lease, or transfer of real property. Before any action, any comprehensive cleanup plan should also be submitted to the appropriate enforcement agency, potentially responsible parties. Of particular concern to commercial and industrial managers is the issue of who has to pay to clean up a problem. CERCLA, discussed previously, imposes liability on persons and organizations responsible for creating environmental hazards. Liability is imposed on potentially responsible parties' PRPs without regard to fault, and any responsible party may be held liable for all costs and expenses associated with the cleanup of a contaminated facility. Current statutes define 4 categories of PRP subject to liability for cleanup costs. The present owner or operator of a facility contaminated by hazardous substances or hazardous wastes. Any person who, at the time of disposal of hazardous substances or hazardous wastes, owned or operated a facility at which the hazardous substances or hazardous wastes were disposed. Any person who generates hazardous substances or hazardous wastes, or who has arranged with another person for the disposal or treatment of the hazardous substances or hazardous wastes. Any person who accepts hazardous substances or hazardous wastes for transport to disposal or treatment facilities, potentially responsible parties. The first category, owner or operator, is of critical importance to property managers. Although statutory law does not define a standard of liability, courts have interpreted liability to be strict and joint and several. Strict liability, as defined in law, generally means that intent or fault is not an element of the act. The act of being an owner or operator is sufficient in and of itself. Joint and several liability means that all such persons, as a group and individually, have complete responsibility for the entire loss, damage, or expense. The government may therefore recover the full cost of cleanup from the present owner or operator, even though that entity did not own the site or participate in the activity that led to contamination. The innocent owner or innocent purchaser is a defense that an owner may use against a claim for liability. An owner may not be held liable if it can be shown that the release or threat of release of a hazardous substance and the damage resulting therefrom were caused solely by an act of God, an act of war, or an act or omission of a third party who is not an employee or agent of the owner-defendant. An act or omission that occurs in connection with a contractual relationship, whether direct or indirect, however, is not excluded. For example, a contractual relationship exists between the grantor and grantee of real property unless the real property is acquired by the defendant after the hazardous waste has been disposed of. The defendant must show that she did not know, and had no reason to know, that any hazardous substance was disposed of on the property. In order for the defendant to show such lack of knowledge, or that the defendant had no reason to know that any hazardous substances had been disposed of on the property, an environmental professional must perform an environmental site assessment that establishes the fact that there is no contamination on the property. If the site assessment finds that the site is not contaminated, the purchaser may rely on the innocent owner defense. A property manager can establish policies concerning management or purchase of property in order to avoid CERCLA liability. However, attorneys specializing in environmental law should be consulted at every step in the process. Environmental assessments. An environmental site assessment, ESA, often called due diligence, is an evaluation to determine if there are any environmental hazards or concerns that could affect the use of the property or impose future financial liability. If a property manager observes environmental concerns, then the manager should suggest hiring a professional to conduct an ESA. Unfortunately, no standard guidelines exist for environmental assessments, although many follow those developed by the American Society for Testing and Materials, ASTM. References should be thoroughly evaluated before any hiring. Also, the manager can recommend that owners work with environmental lawyers as well. Fannie Mae defines an environmental professional as an individual or an entity managed or controlled by such an individual who, through academic training, occupational experience, and reputation, such as engineers, environmental consultants, and attorneys, can objectively conduct one or more aspects of a Phase 1 environmental assessment. Typically, a Phase 1 assessment includes a review of the records, site reconnaissance, interviews with current owners and operators, and an evaluation and report preparation. If the Phase 1 environmental assessment discloses the presence or likely presence of a release or threatened release of hazardous substances on the real property to be managed or acquired, the property manager should recommend further action to confirm the absence of such release or threatened release. In such a case, the manager must arrange for a qualified environmental engineer to conduct a Phase 2 environmental assessment that consists of sampling, testing, and evaluation of substances found on the property. When a separate subdivision of a lot out of a large development project has a high potential for environmental and ground pollution, the parcel should be owned by a separate legal entity in order to help protect the land developer or landlord. Hazardous substances. Learning objective. Name environmental hazards and describe ways that the property manager can minimize their effects. Common hazardous substances. The property manager must understand typical hazardous substances with which he will come in contact and how they may affect a property under management or consideration for purchase or sale. Knowledge of specific hazardous substances and hazardous waste is essential. As stated previously, the terms hazardous substances and hazardous waste are often used interchangeably, but they are not synonymous. A hazardous waste is generally a byproduct of a manufactured item that itself may not be subject to environmental law or regulation. A hazardous substance, however, is broader in scope and may include everyday items such as household cleaning products and paint. Those generally most relevant to property managers are mold, asbestos, radon, carbon monoxide, chlorofluorocarbons, CFC, underground storage tanks, PCBs, and lead paint. Molds. Probably the number one environmental concern today is the presence of molds in office buildings and residential units. Molds are not new, but awareness of possible health effects is. Insurance companies, contractors, sellers, landlords, property managers, and real estate brokers have all faced huge lawsuits. As a result, many insurance companies now exclude any coverage for mold problems. Molds are biological pollutants that require a cellulosic food source, for example wood and moisture, to grow. Because they are devoid of chlorophyll, they do not require light to survive. Indeed, they grow best in dark, damp places. Molds can grow on almost any surface, behind wallpaper, underneath bathtubs and flooring, in air conditioning systems, and in sheetrock or drywall. Key policy. Buildings sealed to prevent heat or cooling loss host the perfect mold growth environment, limited airflow, continued condensation, poorly installed stucco, and poor drainage. Once water gets inside, it is trapped. Molds also like temperatures between 40 and 80 degrees and a relative humidity of about 55%, exactly the conditions in which humans also thrive. As a result, indoor air quality may be 10 to 200 times worse than the outdoor air. Some molds are toxic, but even those that are not toxic may produce spores that cause allergic and respiratory problems in some people, particularly those with asthma or other respiratory illnesses. Thus, not all family members will respond in exactly the same way. The number one prevention technique is moisture control. Property managers should encourage tenants to immediately report any water intrusion from water pipes, air conditioners, humidifiers, etc. Kitchen and bathroom fans should be cleaned regularly and all carpeting removed from bathrooms. If there is a flooding situation, carpeting should be removed as quickly as possible and dried outdoors. Mold inhibitors can be added to paints to further discourage mold growth. Property managers should have certain procedures in place before a tenant ever reports indoor air quality health problems. First, management should carefully discuss mold issues with their insurance carriers and carefully document all maintenance procedures. Building files should contain written records of how management responded to any prior complaints. Legal counsel should review all procedures and managers should use the services of an environmental consultant to conduct air quality measurements. Carbon monoxide. Many buildings today are built nearly airtight to be more energy efficient. These airtight buildings can allow a dangerous buildup of many combustion pollutants, particularly deadly carbon monoxide gas. Carbon monoxide CO, a colorless, odorless, tasteless gas, is one of the most common and deadly poisons in our environment. CO is a byproduct of incomplete burning of fossil fuels, such as gas, oil, coal, and wood, used in engines, oil burners, gas fires, water heaters, and open fires. Even small amounts of CO can displace oxygen cells in the bloodstream, affecting the functions of the heart, brain, and neurological reactions, and while not causing death, may affect normal activities. Many problems arise when tenants use portable space heaters without adequate ventilation. Whole apartment and office buildings have been sickened by faulty water heaters and inadequately vented furnaces. At the beginning of every heating season, the property manager should have the heating system and water heaters inspected. Regular inspections should be scheduled to check all appliances and furnace flues and to see that the unit has adequate ventilation. Flues and chimneys should be inspected and cleaned at least once a year. Tenants should be discouraged from using space heaters or the kitchen oven for heating. Even if not required by law, landlords and property managers should install carbon monoxide detectors in every rental unit and test the detectors monthly following manufacturer's instructions. It is important to remember that carbon monoxide detectors do not function as smoke detectors and vice versa. Chlorofluorocarbons, CFC. Chlorofluorocarbons, CFCs or Freon, are manufactured, inert, non-toxic, non-flammable chemicals gases used primarily as refrigerants in motor vehicle air conditioners, MVACs, building air conditioning units, refrigerators, and freezers. They are also used as industrial cleaning solvents. Unfortunately, once released from their original containers, CFCs float into the stratosphere where they may survive for up to 150 years. A single molecule of CFC can destroy 100,000 molecules of ozone. These holes in the ozone layer allow harmful ultraviolet UV radiation to reach the surface of the Earth, which can lead to skin cancer, eye damage, and weakened immune systems. New air conditioners are using a different product, CFC 134A, which is chemically similar but breaks down more quickly and thus does not reach the stratosphere. In the meantime, many of the older appliances are still leaking CFCs and must be properly disposed of in order to prevent additional leakage. The property manager should consider upgrading the appliances to use the newer environmentally friendly products. New appliances will also be more energy efficient. All appliances, such as air conditioning units and refrigerators, must be properly disposed. The EPA recommends that the following be done. Contact the local public works department and ask about home appliance recycling programs. Contact local home appliance retailers about their refrigerator and home appliance collection program or the availability of refrigerant recovery services. Inform the local hauler or service person about the problem, the law, and the penalties, up to $27,500 fine per day per violation. Only EPA certified technicians who have passed the EPA approved exam should do any work on a refrigeration system because they know how to remove CFCs without releasing them into the atmosphere. The EPA has approved both the Air Conditioning and Refrigeration Institute ARI and Underwriters Laboratories UL to certify recycling and recovery equipment. Approved equipment will carry a label reading. This equipment has been certified by ARIUL to meet EPA's minimum requirements for recycling and recovery equipment, polychlorinated biphenyls, PCBs. Polychlorinated biphenyls, PCBs, are more than 200 chemical compounds not found in nature. Because they are flame resistant, they were used in many consumer products, transformers, lubricating oils, caulking compounds, electrical motors in refrigerators, even in cereal boxes and bread wrappers. Between the 1930s and 1970s, over 1.4 billion pounds of PCBs were manufactured in the United States alone. Even though PCBs are no longer commercially produced in the United States, high levels of the chemicals remain in various parts of the country as a result of leakage of old equipment, leaching from landfills, and from previously contaminated sediments. Unfortunately, they remain in the food chain, accumulating in the fatty tissues in fish and animals. The EPA has classified PCBs as reasonably carcinogenic. In addition, high levels can shorten lifespan, lower fertility, and cause other reproductive problems. About the only way that they can be destroyed is by burning them in a closed environment with a temperature of higher than 2,400 degrees. The commercial or industrial property manager will most likely have to deal with PCBs. The manager should definitely require the services of an environmental consultant before taking on any project where there might be a possibility of the presence of PCBs. Transformers containing PCBs can be identified by an electrical utility. Although this type of electrical equipment is being phased out of use, the property manager should investigate transformers and electrical equipment for which they are responsible and obtain the services of local electrical utility experts to remove them. The penalties are expensive should the PCBs leak into the environment, and they are expensive to destroy. Asbestos. Asbestos management and control was an important concern for commercial property managers in the 1990s, but is lessening today. There are several reasons for this. Asbestos-containing material applied by spray as a surfacing, fireproofing, and insulating material is present in many public and private buildings throughout the country. The use of asbestos-containing materials was banned in the late 1970s. Other asbestos-containing materials such as floor tile, tile adhesives, roofing, and siding were installed well into the 1980s. Asbestos cement water pipe is still in use in some areas. Renovation, remodeling, and demolition of buildings requires proper removal of any asbestos disturbed during those processes. A thorough audit should be made to identify location, type, and condition of asbestos-laden substances in a building. This audit or survey should include drawings, quantities, and the like, so an asbestos management plan can be developed, reviewed, and approved by building management and ownership before removal by professionals can take place on an as-needed basis. Several actions can be taken to manage asbestos. The first is encapsulation, a process that leaves the asbestos in place but encloses it with an adhesive that will permanently immobilize the asbestos fibers, preventing their release into the air. The second method, enclosure, simply erects an airtight barrier which must be impermeable between the asbestos which is left in place and the balance of the space. The third and most drastic, and therefore most expensive, method is removal, which must be handled only by an authorized contractor under the supervision of qualified engineers. Radon. Radon is an invisible, odorless, and tasteless radioactive gas that occurs in small amounts almost everywhere. Its presence in the interior environment of homes and other enclosed structures has been found to cause lung cancer. Of all the environmental risks, it is the easiest to mitigate by sealing the property and installing PVC pipes. A fan at the top of the PVC pipe will suck up vapors in the soil and then disperse them outside. Underground storage tanks. The most common use for underground storage tanks, USTs, is storage of petroleum products. The principal danger from USTs comes from leaking of toxic products. If the liquid in the tank gets into groundwater, it can contaminate a wide area. If more than 10% of the tank is below grade, it is considered an underground storage tank. Property managers of real estate with automobile service stations or shopping centers with service stations or car care centers will be those most concerned with underground storage tank regulation. Industrial users such as chemical plants, metal plating companies, and paint manufacturers also use underground storage tanks to store a variety of toxic liquids, which means that industrial property managers must also be alert to the presence of tanks on their properties. The federal government regulates the registration of underground storage tanks. Legislation requires owners and operators of these tanks to demonstrate their financial ability to be responsible for potential damage from leaking tanks. The removal of a tank and cleanup of the contaminated soil below and around it can become a very expensive process. A number of states have set up funds to assist in removing tanks and cleaning up sites that may have been contaminated by underground storage tanks. State regulations also exist in almost every state, and in many places the removal procedure is administered by state agencies. Formaldehyde. The best known of the volatile organic compounds, VOCs, formaldehyde is implicated as a cause of many indoor air quality complaints. Formaldehyde is a colorless organic chemical that usually has a very strong, pronounced odor. Originally considered harmless, formaldehyde was widely used as an inexpensive preservative and bonding agent used in home insulation and pressed wood particles. It is a component of finishes, plywood, paneling, fiberboard, and particle board in furniture and cabinets. Urea formaldehyde foam insulation UFFI is now legal but rarely used. Formaldehyde is an irritant to the eye, nose, and throat, and symptoms such as headache, wheezing, coughing, fatigue, and skin irritation may be experienced at concentrations found in non-occupational environments. The EPA has classified it as a probable human carcinogen. Formaldehyde is found extensively throughout buildings, particularly newly constructed ones, both residential and commercial. The easiest and least expensive solution to reducing exposure to formaldehyde is to increase ventilation, particularly during renovation and installation of new carpeting and furniture. In extreme circumstances, removal may be necessary. Renovation projects should be done in the spring or summer, when the manager can open windows to allow maximum ventilation. Lead-based paint. Until 1978, when lead-based paint was banned, many paints contained lead as a primary ingredient. When absorbed by humans, excessive lead levels can cause damage to the brain, kidneys, or nervous system. Doses that would have little effect on a grown-up may have serious consequences for a young child. Residential property managers are the most likely to be affected by this potentially dangerous substance. Any manager of any residential property built before 1978 should be well versed on this law. Air quality issues. Air quality issues rank quite high among all building management and design problems, even higher than security, parking, and inadequate workspace. While there is no precise definition for inadequate air quality, it generally includes two recently identified conditions: sick building syndrome and building-related illness. Key policy. Sick building syndrome. Sick building syndrome, SBS, was first described in the 1970s and is used to describe a situation in which reported symptoms among the population of building occupants can be temporarily associated with their presence in that building. Usually, this is an office building. Some of the key symptoms include tiredness or fatigue, headache, dizziness, nausea, irritation of mucous membranes, and sensitivity to odors. In 1991, as many as 24% of U.S. office workers perceived air quality problems in their work environments, and 20% believed that their work performance was hampered. Building-related illness. Building-related illness, BRI, is a clinically diagnosed condition that is caused by toxic substances or pathogens. Unlike SBS, BRI persists when an occupant leaves the building. Symptoms of BRI include hypersensitivity, pneumonitis, asthma, and certain allergic reactions. An investigation and analysis of the implicated building should be undertaken by the appropriate individuals, employer, building owner or manager, building investigation specialists, and sometimes state and local health authorities. In particular, the design and operation of the heating, ventilation, and air conditioning systems should be looked at. It may not be clear what exactly is causing the problem, but possible culprits include poor design, maintenance, or operation of the building ventilation system. Other contributing factors may include contamination by specific pollutants such as molds, humidity, poor lighting, and temperature extremes. Also suspect are volatile inorganic compounds, chemical emissions from products such as paints, adhesives, cleaners, pesticides, fixtures and furnishings, microorganisms, fungi, bacteria, viruses, pollen and mites, and particulates, dust and dander. Both SBS and BRI have become more prevalent in recent years because of higher energy efficiency standards. Energy-efficient buildings are more airtight with reduced ventilation rates. Reduced ventilation means that the agents causing the contamination cannot be easily dispersed. If building occupants are suffering from these two syndromes, increasing ventilation often will improve their condition. Also, replacing interior products such as carpeting, furniture, and paint with newer versions helps, because manufacturers are constantly reformulating their products with safer materials. Emerging hazard control. Learning objective. Explain the importance of employee information and training for dealing with hazardous substances. The Occupational Safety and Health Act of 1970 created the Occupational Safety and Health Administration, OSHA. The act requires all businesses that manufacture or handle toxic or otherwise potentially hazardous chemicals to evaluate and label them for the protection of their employees. Under certain conditions, ordinary chemicals, including cleaning compounds commonly used by property management, maintenance, and building service companies, may be flammable, caustic, toxic, or otherwise dangerous to human health. Thus, OSHA has prescribed appropriate warning labels to apprise employees of all hazards to which they are exposed at the workplace. Label information should include relevant symptoms and recommended emergency treatment plus conditions and precautions for safe use or exposure. Hazard warnings. Producers of chemicals or chemical byproducts are required to evaluate chemical hazards, to label containers according to a Hazardous Material Identification System, HMIS, and to provide material safety data sheets, MSDSs, to serve as hazard warnings to purchasers of their products. MSDSs may be kept in any form, including operating procedures, and may be designed to cover groups of hazardous chemicals in a work area where it may be more appropriate to address the hazards of a process rather than individual hazardous chemicals. However, the employer must ensure that in all cases the required information is provided for each hazardous chemical and is readily accessible during each work shift to employees in their work areas. MSDSs must be made readily available upon request to OSHA representatives. Employee information and training. Employers must provide employees with information and training on hazardous chemicals in their work area at the time of their initial assignment and whenever a new hazard is introduced into their work area. Employee training must include methods and observations that may be used to detect the presence or release of a hazardous chemical in the work area, such as monitoring conducted by the employer, continuous monitoring devices, visual appearance or odor of hazardous chemicals when being released, physical and health hazards of the chemicals in the work area, and measures employees can take to protect themselves from these hazards, including specific procedures the employer has implemented to protect employees from exposure to hazardous chemicals, such as appropriate work practices. emergency procedures, and personal protective equipment to be used. Training shall also include details of the hazard communication program developed by the employer, including an explanation of the labeling system and the MSDS and how employees can obtain and use the appropriate hazard information. A written hazard communication program. With these standards in mind, most property managers will find they have a responsibility to publish and implement a hazard communication standard plan for their buildings. Employers must maintain copies of the required MSDSs for each hazardous chemical in the workplace and ensure that they are readily accessible during each work shift to employees in their work areas. Under the OSH Act rules, a written hazard communication program must be developed and implemented for each workplace. Current written hazard communication program requirements include a provision that requires employers also to provide hazard information to on-site contractor employers who have employees who may be exposed to the hazards generated by the employer. Federal Community Right to Know Act. In 1986, the Superfund Amendments and Reauthorization Act, mentioned earlier, became law, part of which is Title III, the Emergency Planning and Community Right to Know Act. The Act encourages and supports emergency planning efforts at the state and local levels and provides citizens and local governments with information concerning potential chemical hazards present in their communities. Employers required under the OSH Act of 1970 regulations to prepare or have available MSDSs for hazardous chemicals in their workplaces must also submit chemical hazard information to state and local governments. In addition, they must submit an emergency and hazardous chemical inventory form to state emergency response commissions, local emergency planning committees, and local fire departments. Key point review. One of the major concerns of a property owner is obtaining insurance coverage against as many risks as possible at the most reasonable rate. As risk managers for the owner, property managers examine potential risks to see which should be avoided, retained, controlled, and transferred through the purchase of insurance. They may be called on to assist with claims for insured property losses. Property managers may advise the owners, but a final insurance decision should be made by the owner after consulting with her own insurance broker. The owners of a business renting a commercial building need to obtain their own business or commercial policy. The most common types of insurance needed by property owners are special form insurance policies that cover all direct physical damage unless excluded, extended coverage and collateral fire lines, machinery and equipment insurance, consequential loss, use, and occupancy coverage, and commercial general liability, auto liability, and workers' compensation coverage. As representatives of policy buyers, managers shop the market for the most comprehensive and economical coverage. As both an agent and a contracting business person, the manager engages employees and contractors, handles client funds, documents, and records, and maintains his own office and files. Extended fire coverage is a must for the manager's offices, as floater insurance on office contents, errors and omissions insurance, bond coverage, valuable records replacement and theft insurance, general liability policies, and workers' compensation. The manager should also be named as co-insured on all of the owner's liability insurance policies. Key point review. Business non-emergency standard procedures instituted by property managers must follow strict government guidelines and regulations with regard to environmental standards and procedures. One procedure mandated by the 1970 National Environmental Policy Act, NEPA, requires the preparation of an Environmental Impact Statement, EIS, prior to every major federal action significantly affecting the quality of the environment. This procedure is overseen by the Environmental Protection Agency, EPA. Congress has passed laws that address air and water pollution and dumping of hazardous substances. Air quality issues are also on the rise with the increasingly common occurrences of the two air quality related conditions, sick building syndrome, SBS, and building related illness, BRI. The current issue is mold, which can be prevented by quickly containing water intrusion and reducing indoor humidity. Also, better ventilation and products that contain fewer contaminants are other solutions to these problems. The Occupational Safety and Health Act, OSH Act, charges property managers with familiarizing themselves with potentially hazardous substances, asbestos, radon, toxic leaks from underground storage tanks, urea formaldehyde, PCBs, and lead paint. In addition to federal restrictions, an increasing number of environmental protection guidelines and restrictions are enacted by state legislatures. Mandated procedures include thorough environmental evaluations of real property every time it is leased, sold, or transferred.